All right, great, thank you. Please be seated. See, we have some folks here. We're going to try and take you in the order that you arrived. And so the first case I'm going to call is actually at the bottom of the first page of the docket. It's case number ENF 2024-020485. Let's see, it would be, says Gellen Marie Carmel. It's the way that it's specified. Good morning.
I'm attorney Joshua Perez on behalf of a lender who has an interest in the property. We went ahead, we paid a lawn care service to cut the grass. However, that was done at a time after, I believe.
Tell you what, Mr. Perez, I'm sorry. I don't see these cases before I get here,
Yeah, no,
so I have no idea what you're
Okay.
talking about. But let's,
We'll start from the top then.
yeah, it's a violation case. I'm going to hear from the county, assuming they make a prima facie case, then we'll continue on. So let me just swear in, Ms. Switzer, if you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, so whenever you're ready, go ahead and begin, and let's see what we've got.
My name is Kelly Switzer, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Carmela Marie Galin, is not present. This case concerns the property at 3920 Southwest Briar Brook Way, Palm City, Florida, 34990. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Carmela Marie Galin. A copy of the property appraiser's record of ownership is County's Exhibit 1. On February 20th, 2024, I inspected the property. At the time, I observed a vacant lot that was overgrown. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibits 2 through 5. It's a vacant lot, it's overgrown.
Where is the lot? Where on that photo?
It's a 5-acre lot, so it's,
Okay.
I'll have another view and some aerials for you as well. And that's the end of the one side of the lot.
And this is Exhibit 3 we're
3.
looking at?
Yes.
Okay.
Exhibit 4 is the 2023 aerial. This shows the properties on either side being mowed. The one in the middle is the lot in question.
I see. Okay, so back to Exhibits 2 and 3, it's the tall growth that's on the lot,
Correct,
and the rest of it is not.
correct.
Okay. All right.
And Exhibit 5 is showing that hit in 2020 where it had been mowed. Based upon the investigation, I issued a notice of violation to Carmela Marie Glynn on February 20th, 2024, and is marked as County's Exhibit 6. In the notice, I cited the following Martin County Code violations, Section 67.201A, nuisance declared weeds, undergrowth, gender ordinances, Martin County Code. In the notice of violation, the respondent was given until March 6, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on April 17, 2024, and is marked as County's Exhibit 7. The return receipt was not received, therefore I posted the property and at the Martin County Administrative Building. The posting and the affidavit of posting is marked as County's Exhibits 8 and 9.
Okay.
No call or letter from the property owner was received within the time allowed. Therefore, I went to the property again on May 14, 2024, and saw the cited violations had not been corrected. At the time I photographed the property, the photograph accurately shows what I saw then and is marked as County's Exhibits 10 and 11. Is the grass still tall?
Okay.
I request that all the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent, Carmela Marie Galin, be ordered to comply with the cited provisions of the Martin County Code by June 28th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed that amount at the conclusion of today's hearing. This concludes my testimony.
All right. Mr. President, any objection to my accepting into evidence the county's exhibits 1 through 11?
The only thing I would say is Exhibit 11 and 10, it's a little difficult to understand where the property line may or may not be. The aerial ones speak for themselves. I only say this in so much as if I were to go to the property and, because there are vacant lots next to each other, which vacant lot is which vacant lot?
Is there any part of the overgrowth that's on somebody else's property?
To my knowledge, that's what I'm not aware of and why I have some objection to 11 and 10.
Okay, let's
Honor,
ask the
If I
county.
might, if I might, I would question the council's standing to object to anything. I understand he represents a lender. Lender is not a party to this,
Not the owner. Is
not
it?
the owner. He doesn't represent the owner. He represents a
okay.
lender. So I don't, I say I question the
Well, it's
standing
an
to object.
equitable interest. There's no question about that, but notwithstanding that, Mr. Perez took his time to come here and.
Oh, we welcome his participation.
Okay, well, then I'm gonna let him have standing to object, but I think notwithstanding your objection, I'm gonna still enter all of those exhibits for what they're worth. I understand 10 and 11 may have some issues, but there are other parts of the exhibits, looking at 2, 3, 5, which I now understand because of the shape of, particularly shown in 5, and I think I've got enough of a flavor for it to discern
Understood.
the issue.
With that said, however, Magistrate, we did speak, the code enforcement officer and I, before the hearing today. She informed me, and correct me if I'm wrong, you went at 9 in the morning, is that
Yes.
correct? We got a picture at 2:24 from the lawn care people showing the area clear. I showed that to her. And at this point, I think it would be in the best interest of code enforcement, period, to go ahead and have a continuance. I'll drive out to the lot myself and I'll look. The picture that I received was in 2:24 p.m., has a time mark. I showed it to her. She went at 9 a.m. on May 14th. So currently, it's unclear as to what is or what is not cut. And if there is anything that's not cut, obviously, the due diligence will be put forward to get it cut.
All right, obviously, you didn't take the picture, so you can't really authenticate it. And you're not presenting it as evidence, right?
No, I guess I'm just making, in this moment, or
An
tennis
observation.
for continuance.
Okay. Honestly, based on the evidence that I'm looking at, I'm not sure I see the value in that. The same effect may occur, other than the fact that the owner will ultimately be responsible for costs if I rule against her. I am inclined to do that based on the evidence. This is classic tall grass case.
Oh, absolutely. I
So-
understand as to the cost, but as to the fine for $100 a day, that's the only thing.
$100 a day won't occur until June 29th. So
Okay.
I think your interest and perhaps hers are served by my ruling against her. So based upon the evidence and your representations and the testimony that I've heard, I'm going to find that a violation as charged does exist on the property. I'm going to order compliance on or before June 28th, 2024, failing which a fine in the amount of $100 a day will accrue, and that's thereafter, so starting on the 29th. But I am going to award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. So I really appreciate your coming and explaining, and it's good to know that some effort has been made.
Yeah, that's basically my
regard.
purpose today. Thank you.
Yeah, that's really the value of your appearance. And you can get a copy of this if you like before you go, if you want
Yes.
to take one with you. All right, we can make that happen.
Thank you.
Thank you. Mr. Perez, before you go, who is your client? Who is the lender?
It would be Sweet Pea Holding,
Sweet Pea.
Sweet Pea, one word.
Those ladies, I don't know. They're not from America.
Okay. All right. And do they have a first mortgage?
Yes, it's a primary mortgage on the property.
Okay. All right, great. Thank you.
Thank you.
So I light it up to talk.
All right, the next case actually is a fine reduction case. I've got Ms. Tomasco. You gonna hear that, or? Because that's Rachel's case. Yeah, okay. All right, so we'll go right to CASA.
Yes, sir.
CASA 1803 LLC. Let me just, we had this in slightly different order, but not much. All right, so this is case number ENF 2023-120016. The respondent is CASA 1803 LLC. And this is also a violation case, and Mr. Marcos, you're going to testify if you raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, whenever you're ready, you may begin.
My name is Frank Marcos, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, CASA 1803 LLC, is not present. This case concerns the property at 1803 Southwest College Street, Stuart, Florida, 34997 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is CASA 1803 LLC. A copy of the property appraiser's records of ownership is County's Exhibit 1. On December 1st, 2023, Officer Norman inspected the property, and at that time, he observed mini split ACs installed without permit. At that time, he photographed the property. The photograph accurately shows what he observed then and is marked as County's Exhibit 2 and 3.
Okay, 3 is, looks like a courtesy notice, maybe?
It's a door hanger left at the property.
Okay. But Exhibit 2 is the outside component of the mini split?
Correct.
Okay.
Based upon the investigation, he issued a notice of violation to CASA 1803 LLC. On January 16th, 2024, marked as County's Exhibit 4. In the notice, he cited the following Martin County Code violation, Section 105.1, Florida Building Code. Permits when required incorporated by Section 21.1, General Ordinances, Martin County Code. In the notice of violation, the respondent was given until February 15, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and an amended notice of hearing was issued by certified mail on April 17, 2024, and is marked as County's Exhibit 5.
Okay.
The return receipt was not received. Therefore, on April 29, 2024, I posted the property on the Martin County Administration Building. The affidavit of posting and photo of the posting are marked as County's Exhibits 6 and 7. No call or letter from the property owner was received within the time allowed. Therefore, I went to the property again on May 14th, 2024, and saw that the cited violation had not been corrected. At that time, I photographed the property and I did a permit record search of the property, and no permit had been filed. The photograph and screenshot accurately shows what I saw then and is marked as County's Exhibit 8, 9, and 10. That's a screenshot.
Yeah, I can't see that. If you will, maybe just, maybe you can just tell me what,
It shows no permits under that property address.
okay. 9 is of, 9 and 10 are photos of the outside portion of.
Yeah, there are two,
Separate?
yes. That's one. This is the other one on the other side.
Got it. Okay.
I request that all the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent CASA 1803 LLC be ordered to comply with the cited provisions of the Martin County Code by June 28th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting this investigation, and request that the county be reimbursed this amount at the conclusion of today's hearings. This concludes my testimony.
Okay, and is anyone here on behalf of CASA 1803 LLC? Looking out, I don't see anyone. In that case, based upon, without objection, I'll accept into evidence the county's exhibits 1 through 10, and based upon that evidence and your testimony, I'll find that a violation as charged does exist on the property. In this case, the replacement of 2 units, mini-split units, and further order compliance on or before June 28, 2024, failing which a fine in the amount of $100 per day will accrue, and I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. And it is so ordered. Okay,
Thank you.
thank you. Hang on just a second. All right, let's see. All right, no, we can go back to that second case, the Tomasco case. And this is a fine reduction case. It's ENF 2019-070010. And the respondent is Pamela Tomasco. And Ms. Bradley, you're going to testify. If you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and is there someone here?
Mrs. Tramasco is here.
All right, and you are Pamela Tomasco? Okay, great. Good, thank you. Okay, go ahead.
Okay. My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 1370 Northwest Britt Road, Lot 12. On February 19th, 2020, a stipulation and agreed final order was issued by the Code Enforcement Magistrate to Pamela Tomasco for Section 105.1 FBC permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code. Compliance was required by April 30th, 2020. On February 7th, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $112,300. The respondent did pay $400 in administrative costs at the time of signing the stipulation agreement. Staff has determined that a lien reduction is warranted. The respondent was responsible for the violation and brought the property into compliance and has offered to pay $3,369 to resolve the outstanding fines which have accrued. In addition, staff has considered the $33,690 assessed value of the property. So that concludes my testimony for this one. We did the 10% off of the property value as opposed to the fine.
I see it. Okay. And, let's see, do you have any other exhibits?
So Exhibit 1 is going to be the property appraiser. Exhibit 2 is the original stipulation agreement that was signed. Exhibit 3 is the affidavit of compliance with fines. And then Exhibit 4 was the reduction request that came in.
Okay. Ms. Tomaska, if you want to come up to the podium just for a second, let me just swear you in. If you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and your full name and address?
Pamela Jean Tomasco, 1370 Northwest Britt Road, Stewart, 34994.
All right, and you've heard the testimony of the county. Any difference, any changes, anything you want to tell me?
No, I just was interested in making sure the fine didn't go up because it looks like 5 years has gone by that I really had tried to comply, getting an engineer and a
Okay.
architect within that 2 months and presenting everything on April 20th, but COVID had started. So,
Got it. All right, well,
I-
actually, in truth, you did not need to appear. I mean, I'm happy that you're here, and that's good, but the presentation and the stipulation kind of speak for themselves. This is your signature on the back of the stipulation?
Yes.
Okay, good. And you agree with everything that's contained in it? All right, good. Good, thank you. I
Okay.
think that's all I need to hear. Based upon that, I'm going to accept into evidence the county's exhibits 1 through 4 in this case, and based upon the stipulation in the evidence, I'm going to find that it is appropriate to reduce the fine in this case to $3,369. And note that costs have been paid in the amount of, do I have
It
it?
was $400 that she paid at the time.
At $400 in costs. Okay, paid. All right, now, this is a recommended order. It goes to the county commission. They're the actual property holder, if you will, of the own this document. And as a result, the county commission has chosen to keep that as their prerogative. So as soon as the county is able to, they will present it to the county commission. It's pretty rare. Matter of fact, I'm not sure it's ever happened that they've rejected one of these, but that is a possibility, so just be aware that it has to go to the county commission, okay?
at that point, then I get a letter after the commissioners, the
Yes.
Board of
No,
Commissioners?
you'll get an email from me.
You'll-
email.
You'll know,
Oh, okay.
yeah, you'll know that it has been accepted.
Okay.
We do have your email address?
Yes, uh-huh.
Okay, good.
Okay, thank you.
And I note, too, that you presented this copy of Timeline, and I have actually read it. I'm not, well, I can accept it as an exhibit from you if you like. All right, so I'll accept this as Exhibit 1 for the respondent in this case,
Thank you.
and as long as there's no objection.
There's no objection to that,
Okay.
Your Honor.
And we'll just add that to the record, okay?
Thank you very much.
All right.
But
good.
Your Honor, if I may, before we notice there's a possible scrivener's error in
Where
the-
is
in the
that?
document. If we can go to the PAs, number 1, the address of the subject property that the violation was on was 1370 Britt Road, Lot 8.
Not Lot 12?
Tomasco's address is Lot 12. So we want to make sure that the stipulation reflects
does.
that
It's Lot 8.
it applies to Lot 8, not Lot 12. And I believe the stip that we did, we flipped the lot numbers.
Yeah, the
All right.
stipulation says lot 12.
Okay. Well, let's see.
On the first page there.
Yeah. but then the legal description says Lot 8. So I'll tell you what, as long as you agree, I will interlineate that 12 to an 8. Involved a parcel, this is number 1. This fine reduction stipulation and agreed recommended order involves a parcel located at 1370 Northwest Britt Road, Lot 12, Stuart, Florida, which is your address, not the lot that we're talking
That
about.
we're talking about.
So I'm gonna interlineate this to Lot 8, and I'm going to ask you and Ms. Bradley to initial that. And then, thank you very much for making sure the record is straight. Do you each have a pen? Do you need a pen? And I'm going to mark your exhibit as respondent.
Okay.
Exhibit 1. And there's a note on here that says, Your Honor Magistrate, although the appeal wasn't accepted by building, please give consideration to my efforts to comply, and signed by you. And I'm not sure that that has to be part of the record, but
No.
thank you, I appreciate what you were saying. Okay, and I'm going to give this to Ms. Spradley for incorporation in the record. Okay. All right, so now that you've both agreed that it is Lot 8, thank you. I will go ahead and execute the agreed recommended order, and thank you for your time.
Thank you, too.
Okay, we are. Back on the regular docket. Almost, maybe, since I see Ms.
I'm
Espiat
covering for
in here.
Officer Ambrosetti.
Oh, you are, okay.
Yes.
So the Wiggly
Correct.
case? Okay, so this is ENF 2023-120205. Allison M. Wiggly is the respondent, and let me see if I can get 005. 205, Allison Wiggly, okay. And let me go back up here. Okay, I'm with you. If you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right.
My name is Maria Espiat, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Allison M. Wigley, is not present. This case concerns a property at 5134 Southeast Miles Grant Terrace in Stuart, Florida, 34997. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Allison M. Wigley. A copy of the property appraiser's record of ownership is County's Exhibit 1. On December 11th, 2023, an expired AC permit letter was emailed to the contractor of record. A copy of the letter is marked as County's Exhibit 2. On December 12th, 2023, Officer Ambrosetti inspected the property. At that time, he left a door tag for an expired AC permit. At that time, Officer Ambrosetti photographed the property. The photograph accurately shows what he saw then and is marked as County's Exhibits 3 and 4. 3 is the front of the home. It shows here the address. He was in the right address. And 4 is his door tag. Based upon the investigation, Officer Ambrosetti issued a notice of violation to the owner on January 2nd, 2024, marked as County's Exhibit 5. In the notice, he cited the following Martin County Code violations: Section 105.1, permits when required, incorporated by Section 21.1, general ordinances. In the notice of violation, the respondent was given until January 31st, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. An original notice of hearing was mailed out on March 13, 2024, for the hearing on April 17, 2024. That hearing was canceled, so on April 15, 2024, Officer Ambrosetti checked the permit status again, and the permit remained expired. Since compliance was not achieved, an amended notice of hearing was issued by certified mail on April 17, 2024, marked as County's Exhibit 6. The return receipt was not returned, so on April 29, 2024, Officer Ambrosetti posted the property. The photo of the posting and the affidavit of posting are marked as County's Exhibits 7 and 8. 7 is the affidavit of posting, and 8 he posted at the property. No call or letter from the property owner was received within the time allowed. However, Officer Ambrosetti spoke to the contractor of record, who stated they will not be renewing the permit due to the property owner being placed in collection for non-payment. Therefore, Officer Ambrosetti checked the permit status again on May 14, 2024, and saw the cited violation had not been corrected. This is a screenshot. Let me zoom in a little for you. And it shows the status here. It's expired, the permit number, and the description is for the AC. I inspected the property for Officer Ambrosetti on May 14th, yesterday, and saw that the violation still exists, and that's County's Exhibit 10. That's the model number, the same that's on the permit paperwork. I requested all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent be ordered to comply with the cited provisions of the Martin County Code by June 28, 2024, and if not in compliance by then, be required to pay an amount of $100 for every day the violation continues thereafter. The county has incurred a cost in the amount of $575 conducting the investigation, and requests that the county be reimbursed this amount at the conclusion of today's hearing.
All right, thank you. Anybody here on behalf of Allison M. Wigley? Or the contractor, I guess, in this case, because that's where the contact's been. Okay, no one? So without objection, I'm going to accept into evidence the county's Exhibits 1 through 10 in this case. Note for the record that you came late to the party. Yesterday is when you got involved?
Yes.
Good thing. Thank you, I'm glad, because otherwise it was all hearsay, so. So based upon your testimony and the evidence, I'm going to find that a violation as charged does exist on the property and order compliance on or before June 28th, 2024, failing which a fine in the amount of $100 a day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
Thank you. All right, let's see. Switzer, you're back.
I am.
All right. This case is the Richmond case. It's ENF 2023-100462, and the respondent is Michael Richmond. And I have to tell you, my torts professor in law school was named Michael Richmond. I hope it's not the same guy.
I can guarantee it's not.
Okay, all right.
A clear conflict.
All right, so you've already been sworn in whenever you're ready. Go ahead.
My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Michael Richmond, is not present. This case concerns a property at 394 Southeast Cortez Street in Stuart, Florida, 34994. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Michael Richmond. A copy of the property appraiser's record of ownership is County's Exhibit 1. On October 17th, I inspected the property, and at the time, I observed outdoor appliances, trash and debris, and weeds. At the time, I photographed the property. The photograph accurately shows what I saw then and is marked as county's Exhibits 2 and 3. It's the front of his property. The mobile home in the back is where he lives. And then 3, there's some tall grass here.
Oh, okay. Still looking at 2. The mobile
Yes.
home being the white
Correct,
structure?
yes.
That's what we're talking about.
Uh-huh.
Okay. All right, good. Thanks.
Based upon the investigation, I issued a notice of violation to Michael Richmond on October 23rd, 2023. And the notice I cited, I'm sorry, the notice is marked as County's Exhibit 4.
Okay.
In the notice, I cited the following Martin County Code violations. Section 67.201B, trash, nuisance declared, and the following codes have now been in compliance. Section 67.201A, nuisance declared weeds, and Section G2406.3, outdoor appliances. In the notice of violation, the respondent was given until November 22nd, 2023 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on December 13th, 2023, and is marked as Exhibit 5. On December 29th, 2024, a follow-up inspection was conducted, and additional violations were observed. The additional violations is marked as County's Exhibits 6 and 7. This is the roof caving in, right here,
Oh, yeah.
and then a broken window. It's Exhibit 7.
And that's the one that you've outlined in yellow.
Correct,
And that was you that did that?
correct.
Okay.
An amended notice of violation was issued on January 16th, 2024, to include the additional, I'm sorry, excuse me, I got ahead of myself there. The notice of violation is marked as County's Exhibit 8 for the amended notice. The notice, I cited the following violations: 21.115 roofs and drainage, and 21.121 glazing. The owner was given until February 16, 2024 to correct the violation and was informed the need to contact Martin County Code Enforcement upon doing so. The owner reached out to me requesting more time to get the work done, which was granted. Therefore, an amended notice of hearing was sent out on April 17, 2024. The amended notice of hearing is marked as County's Exhibit 9. The return receipt was not received, therefore I posted the property and at the county's administrative building. The posting and the affidavit posting is marked as County's Exhibits 10 and 11. The posting and the affidavit. On May 14, 2024, I conducted a follow-up investigation. The photograph accurately shows what I saw then and is marked as County's Exhibits 12 and 13.
A little better?
Yeah, it's better, but still some trash. And there's another one. Stuff laying around. I request that all of the county's exhibits be received into evidence, and based upon a testimony and evidence, I request that the respondent, Michael Richmond, be ordered to comply with the cited provisions of the Martin County Code by June 28, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the fine continues thereafter. The county has incurred a cost of an amount of $575 conducting this investigation, and request that the county be reimbursed at the amount of this at the conclusion of today's hearing. This concludes my testimony.
All right, and Michael Richmond is here, not here? Seeing no one? He was.
He was, yes.
The gentleman with the
In the
little
back.
girl? Oh, in the back.
Very back, yep.
All right. Okay, did you all speak with him?
He was having a medical emergency, and he had to leave due to that.
Okay. Did he
He-
make any requests? Did he
No.
make any?
He said he knew he was couldn't get it done. He's in poor health, and he couldn't finish the work.
Okay. All right. Well, seems like county's asking for the end, pretty much the end of June. That should be enough time. So hopefully that'll work. Without objection, I'll accept into evidence the county's exhibits 1 through 13 in this case. Based upon that evidence and your testimony, Ms. Switzer, I'm going to find that violation as charged does exist. There's still trash on the property. Violation of 67201B of the code. And order compliance on or before June 28, 2024, failing which you find in the amount of, I'm going to say $50 a day. There's been some effort
Okay.
in this case, and I appreciate that. I'm going to say $50 a day will accrue thereafter. And however, I am going to award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. Now, I see a note that said stipulation, but it really is, there is no stipulation. is
No,
there?
that was, no.
Okay, so I'm just going to cross that out. It's a violation. All right, and the order in front of me is a violation order.
Correct.
Okay. All right. Let me just ask you to take a look at, and I'm not sure one way or the other, on the section 1 of the order, it talks about Monterey subdivision, but it's there's no E at the end, and or R-E-Y. I'm just wondering if that's spelled correctly. If not, I'm gonna go ahead and say,
It's probably a typo.
then I'm gonna say fix it.
Yes, please.
And you don't need to, I'm going to sign the second page. You don't need to bring it back to me as long as that's all there is.
Okay.
Okay. But I am going to circle it, and then you all can figure out if it's not, then you can just
Okay.
reprint the page. If it is, fix it. All right. Thank you. And let's see. You also have the next case, which is the Higgins case. It's case number ENF 2023-110588, and the respondent is Matthew Higgins. And whenever you're ready.
My name is Kelly Switzer, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Matthew Higgins, is not present. This case concerns the property at 2601 Estella Terrace, Palm City, Florida, 34990. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Matthew Higgins. A copy of the property appraiser's record of ownership is County's Exhibit 1. On November 29, 2023, I received a case for an expired permit for a swimming pool. A door tag was left asking to reactivate the permit. A copy of the expired letter and the door tag is marked as County's Exhibits 2 and 3. Expired letter. And 3 is the door tag. Based upon the investigation, I issued a notice of violation to Matthew Higgins on December 28, 2023, and is marked as County's Exhibit 4. In the notice, I cited the following Martin County Code violations: Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1 General Ordinances of Martin County Code. In the notice of violation, the respondent was given until January 26, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. I again checked the permit status on April 2nd and 2024, and the permit remained in expired status. Since compliance was not achieved, and a notice of hearing was issued by certified mail on April 17, 2024, and is marked as County's Exhibit 5. The return receipt was not received, therefore I posted the property and at the Martin County Administrative Building. A photo of the posting and an affidavit of posting is marked as County's Exhibit 6 and 7. Posting and the affidavit of posting. The owner reached out to me May 14th, 2024, and has entered into a stipulated agreement. The agreed stipulated amount of $350 has been paid in full. I request that all the county's exhibits be returned into evidence, and based upon the testimony and evidence, I request that the respondent, Matthew Higgins, be ordered to comply with the cited provisions of the Martin County Code by September 27th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. This was a very last-minute stipulation. He is in Miami. He is overnighting the original
All right.
stipulation.
Okay, let me just look at it. All right, so we've got a photocopy of his signature.
Correct.
All right.
He is going to be sending the original overnight.
All right, so I'm going to accept into evidence the county's exhibits 1 through 8 in this case, and based upon the stipulation, find that it is appropriate for him to comply on or before September 27th, 2024. And based upon the stipulation, it does indicate a fine in the amount of $100 a day would accrue thereafter. And as Ms. Switzer has testified, $350 has already been paid to the county. So I'm going to go ahead and approve the agreed order. And I will execute the original whenever it shows up.
Okay, thank you.
Okay. All right, so let's see, the next case is case ENF 2023-120071, Elizabeth Dara Borges and Diane Borges.
Correct.
All right, and whenever you're ready.
Okay. My name is Kelly Switzer, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondents, Elizabeth Dara Borges and Diane Borges, are not present. This case concerns a property at 8500 Southeast Eagle Avenue, Hobe Sound, Florida, 33455. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Elizabeth Dara Borges and Diane Borges. Copy of the property appraiser's record of ownership is County's Exhibit 1. On December 4th, 2023, Nicholas Fisher, a code compliance investigator for Martin County, inspected the property. He found trash, broken windows, and trash and debris on the property. The trash and debris has since been resolved. At that time, he photographed the property. The photograph accurately shows what he saw then and is marked as County's Exhibits 2 and 3. There's broken windows in the front. And another one here.
Okay. All right.
On February 27, 2024, we received an additional complaint regarding the home not having power. I contacted FP&L for confirmation. The email correspondence regarding the power status is marked as County's Exhibit 4.
Interesting email from
Yeah.
FP&L. We don't give away free power. Okay.
Based upon the investigation, I issued a notice of violation to Elizabeth Dara Borges and Diane Borges on April 15, 2024. The notice of violation is marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violations: Section 21.21 glazing, general ordinances, and Section 21.21 electrical facilities required. In the notice of violation, the respondent was given until April 29, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. A notice of hearing was also issued by certified mail on April 15, 2024, and is marked as County's Exhibit 6. The return receipt was not received, therefore, I'm sorry.
Go ahead. Sorry. Yeah,
Good?
ma'am,
Okay.
go ahead.
The return receipt was not received, therefore I posted the property and at the Martin County's Administrative Building. The posting and the affidavit of posting is marked as County's Exhibit 7 and 8. Those are mixed up a little bit. An email I received for an updated FPNL, from FPNL updating the power status is dated April 30th, 2024, and is marked as County's Exhibit 9.
Okay. So,
Showing that the power has been restored to the property.
all right.
Okay. As of May 14, 2024, a permit application for new windows has been applied for but has not been approved. A screenshot showing the permit application status is marked as Exhibit 10. That's showing waiting on applicant. On May 14, 2024, I also went to the property and found that the windows were still not repaired. Photos of the damaged windows are marked as County's Exhibits 11 and 12. Still missing panes. I request that all the county's exhibits be turned into evidence, and based upon the testimony and evidence, I request that the respondents Elizabeth Dara Borges and Diane Borges be ordered to comply with the cited provisions of the Martin County Code by June 28, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the fine continues thereafter. The county has incurred a cost of the amount of $575 conducting this investigation and request that the county be reimbursed this amount at the conclusion of today's hearing. This concludes my testimony.
Okay. Let me ask, you're asking for compliance by the end of June, and based upon the status of the building permit application,
Well, we cited for them to fix the windows. They took it upon themselves to apply for a new permit to change out the windows,
okay?
so they haven't fixed, the windows are obviously still broken.
Well, let's assume that the fix that they've chosen is replacement.
Correct.
I mean, that seems to be what they're doing. And I guess what you're saying is, well, they could always just throw another awning window in there.
They could put some new glass into the windows, correct, to fix the,
Okay. All right, and are they aware of that?
yes.
They are, okay. All right, so if push comes to shove, they can get it fixed in a day or two?
In a day, yes.
Okay.
They were made aware.
All right. Okay, so anybody here on behalf of the Borges? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 12 in this case. Based upon that evidence and your testimony, I'll find that violations as charged to exist on the property. And are the weeds, that's all?
Everything's been taken care of
Taken
except
care
for
of.
the windows.
All right, so really it's just the 21.121.1 glazing
Correct.
issue, and I'm going to get rid of those other two. And order compliance on or before June 28, 2024, failing which a fine in the amount of $100 per day will accrue. And I will further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. And it is so ordered. Okay, very good. Let's see, next case. Next case. Not Rachel. All right, Ms. Bush, it's the last case on the docket, William Pratt.
Yes.
All right, it's ENF 2024-010616-01. Respondent is William Pratt. And if you'll raise your right hand, I'll swear you in. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
All right, good. Whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I am a code compliance investigator for Martin County. The respondent, William Pratt, is not present. This case concerns the property at 8555 Southeast Main Grove Street in Hope Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser in Martin County, the property owner is William Pratt.
Okay.
A copy of the property appraiser's record of ownership is County's Exhibit 1.
All right.
On February 1st, 2024, I inspected the property, and at that time, I observed a structure indoor shed being constructed without permit and left a door tag to apply for and obtain an issue permit for the work being completed. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibits 2 through 4. 2 is the door tag. 3 is the shed. It's the opposite side of the screen patio. And here's a closer photo of it.
Okay.
Based upon the investigation, I issued a notice of violation to William Pratt on February 21st, 2024, marked as County's Exhibit 5. In the notice, I cited the following Martin County Code violations: Section 105.1, FBC, permits when required, incorporated by Section 21.1, General Ordinances of Martin County. In the notice of violation, the respondent was given until March 12, 2024, to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on April 9, 2024, and is marked as County's Exhibit 6.
Okay.
The return receipt was not received. The property and county administration was posted on April 18, 2024. The affidavit of posting is marked as County's Exhibit 7. On May 2nd, 2024, the owner William Pratt, entered into a stipulated agreement. The owner agrees to come into compliance with the cited provisions of Martin County Code by August 30th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 per day for every day the violation continues thereafter. The owner has paid the agreed administrative cost of $350, and at this time, I am requesting that all the county's exhibits be received into evidence.
Okay, so Mr. Pratt is not here. I'm looking out, seeing no one. And so without objection, I'll accept into evidence the county's exhibits 1 through 7 in this case. Note for the record that there is a stipulation and a recommended agreed final order in this case. And it does, as you state, require compliance owner before August 30th, 2024, failing which a fine in the amount of $100 a day will accrue. And note for the record that $350 has already been paid to the county.
Yes,
in
sir.
costs. Okay. All right, and the respondent, William Pratt, has executed the agreement, as have you on behalf of the county. So I'm going to find that the agreed order is proper and go ahead and execute it.
Thank you, Special Magistrate.
Thank you. see. Ms. Bradley, we're beginning on the top of page 2,
Yes, sir.
is that right? And I have not sworn you in. Oh, I did?
Yeah, I testified for the other one.
Oh, yeah, you did. Okay. So this is the Lyons case, Milton R. Jr. Lyons, Lyens, and it's case number 08-002-0614.
Yes, sir.
A moldy oldie. And let me just catch up with you here. Okay. And whenever you're ready.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 7708 Southeast Fork Drive in Stewart in Martin County, Florida. On May 20th, 2009, an order finding violation was issued by the Code Enforcement Magistrate to Milton R. Lyons Jr. for Section 21.99 Accessory Structures, General Ordinances, Martin County Code, Section 91.34.A, Generally Inoperable Vehicles, General Ordinances, Martin County Code, and Section 3.11 Permitted Uses, Martin County Land Development Regulations. Compliance was required by June 22nd, 2009. On April 3rd, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $1,619,700 plus cost in the amount of $575. Greg Lyons is the current owner of the property pursuant to a warranty deed enhanced life estate recorded in official record books 3401, page 1917, Martin County, Florida Public Records. The respondent has no remaining interest in the property. Staff has determined that a lien reduction is warranted. The current owner was not responsible for the violation. However, he did bring the property into compliance and has offered to pay $5,000 to resolve the outstanding fines which have accrued. In addition, staff has considered the $50,000 assessed value of the property. So this one is the same. They're paying the 10% off of the property value.
Ma'am.
And Exhibit 1 is the property appraiser showing that Greg Lyons is the owner. Exhibit 2 is the original order against Mr. Lyons.
Yes, note who signed that.
Mm-hmm.
That order in 2009.
The recorded affidavit of compliance with fines is Exhibit number 3. And then Exhibit number 4 was the reduction request from Greg.
Okay. It's a Realtor making that request, and it has closed? It's now?
No, it's actually waiting for this to close.
It is, okay.
Yes. They were waiting for the approval.
All right. All right, so, and Mr. Greg Lyons is not here.
No, sir.
Okay. So without objection, I'll accept into evidence the county's exhibits 1 through 4 in this case, and note that there is a fine reduction stipulation and agreed recommended order signed by Gregory Lyons on behalf of himself as contract purchaser of the property, and that the
He's actually,
property has been brought into compliance.
he's actually the owner of record right now. He's the one that's selling the property.
Oh, he's selling it?
Yes, sir. He inherited the property from his father.
Gotcha. All right. I couldn't figure out which direction it was going. All right, so he's the seller.
Yes, sir.
All right. That's fine. Okay. All right. Anyway, note that the stipulation does require a fine being paid in the amount of $5,000, and that is 10% of the assessed value. And Gregory Lyons has executed, as have you, Ms. Bradley, on behalf of the county, so I'm going to go ahead and enter the agreed recommended order in this case. And Again, this goes to the county commission for approval. Okay. Next, we have the Groves case. This is 11-0047-262. Looks like you're clearing up a lot of old cases here.
Yeah.
And the respondent is Groves 14 LLC. And I see the property owner is Discovery Hope Sound Investors LLC.
Correct.
Yeah, go ahead.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 4384 Southeast Santa Barbara Terrace in Martin County, Florida. On December 20th, 2011, a stipulation and agreed final order was issued by the Code Enforcement Magistrate to Groves 14 LLC for Section 105.1 FBC permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code. On March 21st, 2012, an amended stipulation and agreed final order was issued to Grove 14 LLC, adding additional time. On June 13th, 2012, a second amended stipulation and agreed final order was again issued to Grove 14 LLC for additional time once again. On November 6, 2012, a third stipulation and agreed final order was issued granting a final extension of time. Compliance was required by February 1st, 2013. On April 22nd, 2004, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $156,400. Discovery Hope Sound Investors LLC are the current owners of the property. Pursuant to a special warranty deed recorded in Official Record Book 3402, page 1730, Martin County, Florida, Public Records. The respondent has no remaining interest in the property. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation. However, they have offered to pay $15,640 to resolve the outstanding fines which have occurred. And that concludes my testimony for this one.
Okay. No, just because I let Michelle Owen get away with 3 stipulations, and doesn't mean I would let you do that.
Craziness.
Okay.
So this one, the property appraiser is number 1, showing that Discovery is the new property owners. Exhibit 2 is the original stipulation agreement that was put in place. Exhibit 3 is the amended stipulation agreement that was put in place. Exhibit 4 is the second amended stipulation. Exhibit 5 is the third and final amended stipulation agreement that was done. Exhibit 6 is the affidavit of compliance with fines. And then Exhibit 7 was the reduction request that came from Discovery.
Okay. And I don't remember the particulars of the case, but it is really highly unusual to have that kind of situation where.
There was some site planning issues that hung them up back when Grove owned it and was trying to change. This is where the polo club is, or the polo fields are out in Hope Sound.
They were trying to change zoning and.
Yes. So that was why we gave them so many steps.
Got it. All right. So without objection, and there's no one here on behalf of Groves 14 LLC that I see. So without objection, I'll accept into evidence the county's exhibits 1 through 7 in this case. Based upon the evidence, your testimony, I'll find that it is appropriate to reduce the fine from $156,400 to $15,640. And also note that Joseph Aronson, Vice President for Discovery Hope Sound Investors LLC, is executed on behalf of that entity, and that, Ms. Bradley, you have executed. So this is an agreed recommended order going to the County Commission, and it is so ordered. Okay. Let me just catch up here. Is this another Lyons case?
Yes, sir.
It is,
There's
okay.
two of them.
All right, so the next one is also in the name of Milton R. Lyons. It's case number 11-005-1116. And let me get that one. Okay.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 3069 Southeast Fairmont Street in Stuart, Florida. On June 20th, 2012, an order finding violation was issued by the code enforcement magistrate for Section 105.1 FBC permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code. Compliance was required by July 20th, 2012. On February 12th, 2014, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $421,800 plus cost in the amount of $500. This case was regarding a fence permit that was pulled two owners before Milton Lyons owned the property. Milton Lyons purchased the property on September 2nd, 2011. Greg Lyons received the property pursuant to a warranty deed enhanced life estate on October 4th, 2023, recorded in official record book 3401, page 1919, Martin County, Florida, public records. The respondent has no remaining interest in the property. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation. However, he brought the property into compliance and has offered to pay $2,500 to resolve the outstanding fines which have accrued. Staff has determined that due to the fact that both Mr. Lyons were not the original people to apply for and receive the permit, that a reduction lower than the standard 10% is warranted. And that concludes my testimony on this one.
All right, do we know the value of this property, let's say?
So, showing the property appraiser, the market value is $197,300.
Okay, so you're a little higher than that, than 10%. Okay.
Yes, sir.
All right. So without objection, I will accept into evidence the county's exhibits 1 through 4 in this case. Again, Mr. Lyons is not here on behalf of himself, but he has executed the stipulation, and it does reflect that he is willing to pay $2,500.
You want me to put the exhibits on file?
Oh, yeah, there were exhibits in this case. I've already looked at them.
No. Exhibit 2 is the, obviously, Exhibit 1 was the property appraiser. Exhibit 2 is the original recorded order. Exhibit 3 is the recorded affidavit of compliance with fines. And then Exhibit 4 was Mr. Lyons' request
All right.
for the reduction.
Again, without objection, I'll accept into evidence the county's exhibits 1 through 4 in this case. Just for clarity for folks at home, I actually can look at the evidence as we go, notwithstanding what's on the TV screen. So I had already looked at them. Okay, so I think that takes care of that case. Let me just execute the agreed recommended order. Again, this is recommended, goes to the county commission. All right. The next case is the Heasley Estate case.
Yes, sir.
And this is the estate of Catherine Heasley. It's case number 150092670. And let me catch up here. Okay.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 1464 Northeast Croton Street, Jensen, in Martin County, Florida. On October 21st, 2015, an order finding violation was issued by the code enforcement magistrate to Catherine Heasley for Section 21.121.2, Openable Windows, General Ordinances, Martin County Code, Section 21.111, Protective Treatment, General Ordinances, Martin County Code, and Section 67.201.b, Nuisance Declared Trash, etc., General Ordinances, Martin County Code. Compliance was required by November 23rd, 2015. On February 24th, 2020, an affidavit of transition and accrued fines and costs was issued reflecting an outstanding fine in the amount of $371,400 plus cost in the amount of $575. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation. However, the county placed the property under condemnation. The estate did bring it into compliance and have offered to pay $27,213 to resolve the outstanding fines which have accrued. In addition, staff has considered the $272,130 assessed value of the property. And just so you are aware, Mr. Nicoletti, you have actually done this one once before. They had a probate issue. So it did not meet the timeframes for it. That's why it's back before you.
All right.
But that concludes my testimony on this one. Exhibit 1 is the property appraiser, showing that it's in the estate. Exhibit 2 is the original order that was placed on the property. Exhibit 3 is the affidavit of transition where we rolled it into a condemnation. And then Exhibit 4 is the fine reduction request that came from Caitlin.
They're willing to pay $27,213. And 3,700.
Well, you have another case before you, that's what that one's for.
Okay, that's not,
That's not tied to this one.
oh yeah, okay. I see, that's a 2018 case. All right, so. All right, so really, we're looking at the 10% of the assessed value.
Yes, sir.
All right. So without objection, I'll accept into evidence the county's exhibits 1 through 4. In this case, based upon that evidence and your testimony, I'll find that it is appropriate to reduce the fine from $371,975 to $27,213, which is 10% of the assessed value of $272,130. Also note for the record that property owners Caitlin Kelly, Catherine Kelly, and Kristen Gavel have executed this agreement electronically, and I'll find that that is appropriate in this case. And note that, Ms. Bradley, you've signed on behalf of the county. So I'm going to go ahead and execute the agreed recommended order in this case. And okay, that'll take care of that one. Let's see, now there is another Heasley case.
Yes, sir.
All right, so this is ENF 2018-030519, and it is presumably in the estate of Catherine Heasley.
Yes, sir.
Okay, go ahead.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 1464 Northeast Croton Street, Jensen Beach in Martin County, Florida. On October 17, 2018, an order finding violation was issued by the code enforcement magistrate to Kathleen Heasley for Section 21.115 roofs, General Ordinances, Martin County Code. Compliance was required by November 30th, 2018. On February 24th, 2020, an affidavit of transition and accrued fines and costs was issued reflecting an outstanding fine in the amount of $36,700 plus cost in the amount of $575. Staff has determined that a lien reduction is warranted. The respondent's estate was responsible for the violation. However, the county placed the property under condemnation. The estate did bring the property into compliance, and they have offered to pay $3,727.50 to resolve the outstanding fines which have accrued. This is the same situation. We did bring this before you before. They are paying 10% of the total fine on this one.
Yep, I see that. Okay, so without objection, I'll accept into evidence the county's exhibits 1 through 4 in this case. And based upon the evidence in your testimony and the fine reduction stipulation in front of me, I'll find that it is appropriate to reduce the fine from $36,700 plus $575 in costs to $3,727.50. And note again that Caitlin Kelly, Catherine Kelly, and Kristen Gabel have all signed electronically, as you have, Ms. Bradley, in ink. And I'll go ahead and approve the agreed recommended order.
So Exhibit 1 is the property appraiser. Exhibit 2 is the re-recorded order finding violation that was issued. Exhibit 3 is the affidavit of transition. And then Exhibit 4 is the reduction request that came in from Caitlin on this
Maybe
one.
we ought to change how we present these, since
I can do it as I go if it's
I'm
easier for
following
you.
along, and I'm
I know.
hitting each one of those exhibits as you testify, so maybe.
I can do it
it's
that way
easier
if you
do it
want me
that
to.
way. Yeah, it would.
Okay.
Less confusing for the public, maybe. I mean, I know what we're doing, you know what we're doing. Got to get it in the record, though.
I can do it that way.
All
That's fine.
All right, so once again, I'll accept into evidence the county's exhibits 1 through 4 in this case. Good, okay, and I've already executed the agreed recommended order. All right, moving along. The next case, is it Conifal? I don't know how you pronounce that. Conifal?
Yeah, Knoffel.
Could be that, too. All right, it's case number ENF 2018-110099, Joanne Konefal, Konefal. And let's see, 099. Okay.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 1027 Southwest Bermuda Terrace in Stewart in Martin County, Florida. County's Exhibit 1 is the property appraiser showing the property owner.
Which is not
Correct. It was sold.
Konefal. Okay.
On September 18th, 2019, an order finding violation was issued by the code enforcement magistrate to Joanne Knoffel for Section 21.122 Doors, General Ordinances, Martin County Code, Section 21.111 Protective Treatment, General Ordinances, Martin County Code, Section 21.132 Interior Surfaces, General Ordinances, Martin County Code, and Section 21.105 Swimming Pools, General Ordinances, Martin County Code. So Exhibit 2 is the original order that was recorded.
Okay.
Compliance was required by March 31st, 2020. On April 9th, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $586,400 plus cost in the amount of $575. So Exhibit 3 is the recorded affidavit of compliance. and I think it's Bernard and Kelly Van Tor, are the current owners of the property pursuant to a general warranty deed recorded in Official Record Book 3423, page 750, Martin County, Florida Public Records. The respondent has no remaining interest in the property. Staff has determined that a lien reduction is warranted. The current owners were not responsible for the violation. However, they brought the property into compliance and have offered to pay $58,697.50 to resolve the outstanding fines which have accrued. And Exhibit number 4 is their reduction request, asking for the fine reduction.
Okay. All right, so, nobody here on behalf of the owners or Ms. Conifer? Without objection, I will accept into evidence the county's exhibits 1 through 4 in this case. Based upon that evidence, I'll find that it is appropriate to enter an agreed recommended order based upon the stipulation, reducing the fine to 10% of the assessed value of the property. And let's see, she's offered, so it's $58,697.50 as the 10% of the assessed,
No, it's 10% of the total fine.
of the total fine.
Yes, sir.
Oh, yeah. I'm reading along now and seeing that the outstanding fine was $586,400 plus cost.
Yes, sir.
Okay, all right.
It was cheaper than their property value.
Ah, okay. All right, and note also that the Van Tours, Berend and Kelly Van Tour have executed the agreement. And is that a wet signature? It's black.
Yes.
So I'm
Yes,
hard to
sir.
tell. All right, and then Ms. Bradley, you've also executed on behalf of the county. And I'll go ahead and enter the agreed recommended order in this case. Okay, very good. And let's see, we're getting down here, let's see, the Zampano case is next. It's case number 2021-010420-01, Michael V. Zampano. And let me catch up. Okay.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 4639 Southeast Bayshore Terrace in Stewart in Martin County, Florida. The property appraiser is Exhibit 1. On May 19, 2001, an order finding violation was issued by the code enforcement magistrate to Michael V. Zampano for Section 67201.A, nuisance declared weeds, undergrowth, General Ordinances, Martin County Code, and Section 21.105, swimming pools, General Ordinances, Martin County Code. So Exhibit 2 is the original recorded order that was put in place.
Okay.
Compliance was required by June 30th, 2021. On May 1st, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $150,300 plus cost in the amount of $575. So the affidavit of compliance with fines is Exhibit number 3.
Okay.
Staff has determined that a lien reduction is warranted. The respondent was responsible for the violation, and they brought the property into compliance and have offered to pay $15,087.50 to resolve the outstanding fines which have accrued. And Exhibit number 4 is his reduction request. And that concludes my testimony for this one.
Okay. All right. Was he the owner at the time?
Yes, sir. He's who we recorded the original order against.
Yeah. Yeah. Okay. All right. Well, that's a hard lesson to learn, isn't it? All All right, then Mr. Zampano is not here, so without objection, I'll accept into evidence the county's exhibits 1 through 4 and find that it is appropriate to reduce the fine in this case to $15,087.50 to be paid to the county in accordance with the stipulation. And note that Michael Zampano has executed the agreement on behalf of himself, and Ms. Bradley, you have on behalf of the county in that effect. Okay, I'll go ahead and approve it. All right. Let's see, wait a minute. Sorry, just catching up here. All right, good. All right, so the last case is Alex and Leslie Curtis. And it's case number ENF 2023-07. 0213. 0213. Go ahead whenever you're ready.
My name is Rachel Spradley, and I've been sworn in. I'm the nuisance abatement coordinator for Martin County. This case concerns the property located at 132 Southeast Paradise Place, Stewart, in Martin County, Florida. And the property appraiser is Exhibit 1.
Okay.
On October 18th, 2023, an order finding violation was issued by the Code Enforcement Magistrate to Alex and Leslie Curtis for Section 105.1 FBC permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code. Exhibit 2 is the original order. Compliance was required by November 30th, 2023. On April 23rd, 2024, an affidavit of compliance with accrued fines was issued reflecting an outstanding fine in the amount of $14,400. Staff has determined that a lien reduction is warranted. Exhibit 3 is the affidavit of compliance with fines.
Okay, thank you.
Staff has determined that a lien reduction is warranted. The respondents were responsible for the violation. They brought the property into compliance and have offered to pay $1,440 to resolve the outstanding fines which have accrued. And Exhibit 4 is their reduction request.
All right,
And that concludes my testimony for this one.
okay. All right, so without objection, I will accept into evidence the county's exhibits 1 through 4. And note that the stipulation reflects accrued fines in the amount of $14,400 and an offer to pay $1,440 to resolve the fines. Executed by Alex Curtis and Leslie Curtis on behalf of themselves and Ms. Bradley on behalf of the county. Find that it is appropriate to enter the agreed recommended order in this case. All right. And let's see, there is a set of minutes for the March 20th hearing, and I have reviewed them. And we'll approve them as filed. Okay. Anything else to come before us today?
No, sir.
All right, and the next hearing is what, June
The 19th of June.
19th? June 19th. Okay, great. All right, so we will see you all then, hopefully. Thank you. You.